Good afternoon. Our presentation will be for 40 minutes, and we understand that everyone is a bit tired. 40, because there's two of us. Oh, we can make it 14 if you cooperate. So I'm going to start with saying that 3 months ago, me and Agnieszka were in India because we are coaches for the mediation team, and we were taking part in that international event. And we were observing one of the sessions. So during that session, during semifinals, our girls, we had a team that consisted of 2 girls, were playing negotiators. So in our opinion, the session went quite good, quite decent. And once we heard the feedback, our perception of it might have changed a bit. So what the judge said is that she turned into a mediator and said, very decent job, good opening statement, etc., etc. She went to the team that we were going against and said, you know what, you were very collaborative, you were very open. And then she turned to our girls, to the team, and she said, you know what, I have to say it, you just got too much. So the girls left the room after the feedback, and they approached us and said, Jacek, Aga, we're negotiators. How could we possibly get too much? So we were speaking with the judge, and during the events, she justified her opinion as exactly that she's not even sure if the agreement was within ZOPA.
This brought us to a conclusion that ZOPA is something that we want to more thoroughly look at. And that's why we chose to take you all today for a journey on a mediation session through the lenses of ZOPA. Because ZOPA is something that defines dynamics of mediation and how parties perceive ZOPA, their ideas on it actually makes huge difference as to how the process goes through and if it ends with an agreement or not. On a personal note, as coaches, we deem it very, very useful to teach our students about ZOPAs, for them to make informed decisions. And just 2 notes on the side. What we'll be talking about today is not about what's supposed to be, sorry for the mic, but how it usually looks like in civil and commercial disputes. Those are the particular cases that we would be referring to with our analysis and our journey. So, what is the said ZOPA? We have a room full of people interested in mediation, so I bet that more than everyone here came across the concept of ZOPA. There are multiple definitions, but the most famous one is that ZOPA, the zone of possible agreement, is called a bargaining range, which exists if there's a potential agreement that would benefit both sides more than their alternative options do. This is a definition by Ari and Fisher, included in Getting to Yes. Where it brings us.
Exactly, so basically we all know the concept, and general understanding of ZOPA is that this is the space between 2 buttoners. Can we all agree? Please raise your hand if you agree with the statement. Is it a space between 2 buttoners? Do we know the concept of buttoner?
Best alternative to...
So is it or is it not? It is. In my opinion, it isn't. So let's break it down. It is, but it's inaccurate statement. Basically, there is a difference between buttoner and RV, which is reservation value, walk-away point, however we like to call it. And we're not going to focus on the concept of ZOPA, but we want to make sure to break this down so we have the clear understanding of what we're talking about. And that would be the case. Just imagine that you're going to Riga for the amazing conference, and you have to book a room in a hotel. You've got 2 options. One already booked, you've got you can cancel the reservation free of charge. So the price for the night in the room that you booked is 100 euros per night. What's wrong with the hotel is that it's actually 1 hour of a drive to a place when the conference is. So you negotiating an agreement with another hotel, And this hotel is a walking distance, 3 minutes walking distance from the venue that the conference is taking place. So you obviously want to book the other hotel. How would you calculate what is your reservation point while negotiating with the other hotel? You see, BATNA is external to negotiation that we're conducting. So basically BATNA is the offer that we already have. So how would you calculate, to actually describe the ZOPA, how would you calculate your reservation value?
Is it solely based on the price for a night? Oh, I see some heads going, no.
So basically, probably what you would do is to ask yourself a very straightforward question. How much do I value 2 hours of my time? And then you would put a number on it, and it would turn out that the BATNA would be, for example, 100 for a night, but the reservation value would be 120, 150. I don't know how much you value 1 hour, obviously. I value it
including
quite much.
taxi, right?
So this is basically the difference that we already wanted to break down. So the more accurate understanding of ZOPA would be actually a space between the two RVs, not two BATNAs.
What is also very particular to ZOPA is that very often how we are taught of ZOPA is only based on one factor. Let's say the price. From point 0 to point 100, from point 80 to 150. That's a simplification. And that very often leads to a conclusion that, ZOPA, theoretical concepts, not really playing a role in my mediation, in my negotiation, and I don't really know how to use it. How about looking at ZOPAs from a multi-dimensional perspective, taking into account a lot of factors, and I'm not only saying like 2, price and time. Make it a sphere. It's getting more difficult to define the boundaries, but it provides for a fuller picture and more informed decision.
We would be happy to visualize it, but we're lawyers and not designers, so we had no idea how to make it 3D, to be honest. So there is one more issue, that when we're discussing ZOPA, we have to make sure that we understand that when we're discussing zone of possible agreement, we're taking into consideration factors that are not up to parties to decide. So, for example, I work as a lawyer with the Capital Group, and trust me, 20% of the agreements that they come up with somehow infringes competition laws. So what I'm saying is no. So just make sure, both as a mediators, probably, it's going to be probably covered during another panel that we're looking forward to hear, but also as a lawyers, that you understand that the ZOPA is something that party actually can agree upon. So this is one example. Law is a factor that actually determines ZOPA as well.
Another example of external factor is the third-party consent, wherever needed. I bet that all of us had once a decision to be made, but you were walked on by the other side, who simply said, no, I'm sorry, I need to ask somebody else for consent. And the idea for the commitment, for the binding commitment for agreement, was just very well misshaped because of taking into account only factors that you can make a decision on within the two of you that sit in the room.
And that's it about theory. But there is one problem about theory. That theory usually talks about objective BATNA. So where we reading in RE, when we're reading Fisher and generally everything that was produced since then by Harvard, we discussing objective BATNA. The problem with that is that there is only one person, supposedly you believe in it, that actually knows what the objective BATNA is, and
God only knows.
God only knows. So basically what we think is that when you're trying to understand the dynamics that are happening during the negotiation or during the mediation that we will focus on, is that you have to take into consideration multiple ZOPAs, not only one ZOPA. Because from our perspective, since mediation is happening for the common mutual acceptable consent of the parties, what they think is actually more important than what is objectively verifiable. So you've got multiple subjective ZOPAs.
For an example, if we think of a mediation room, we have a mediator who is prepared to a case. So a mediator supposedly have, or mediators, they have their own idea of ZOPA before it even starts. Then, who we have? We have two parties. Whoa. We have two parties. And what happens then? They don't come as a blank sheet to a mediation. They have their own ideas of ZOPA. Otherwise, they would never come to the table, because if there's no idea, hopefully. If there is no option for an agreement, why even bother? And then, let's add to it one more. Mediator has the idea of party ZOPAs. I know it's getting tricky at this stage, but we need to deal with it.
So basically, Agnieszka already enumerated like 5 ZOPAs, and there are plenty more. And each plays an important part for the dynamics that are happening during the negotiation. But the crucial question is not whether we can theoretize about ZOPA. The crucial question is, can we use it? Is it a theoretical concept, or is it something that actually we as mediators or lawyers can put into practice while mediating?
Can we argue that ZOPA exists? Yes, no, objective, subjective? Good. Do you think that we have sufficient tools to define it? More or less. Okay, so how to use it?
Exactly. One of the lecturers today said that mediation is all about practice, and we definitely agree. So therefore, we're going to ask you 3 questions, and we would kindly ask you to respond to it yes or no. Just imagine the scenario that someone is coming to you as a lawyer. Let's call him, is there any nice name in, do you have any nice name that you would like to use? How? Yanis? Yanis comes to you and he says that he has a brother, that he doesn't want to have any contact with it. I'm going to simplify the case. There is an estate, and the hearing, he filed for dividing the division of the estate, and the hearing is within the month. What is within the estate?
Sorry. What happens is that the only living parent of both siblings passed away recently, and there is the estate to be shared and dealt with. What we have in it is house of a value of 390,000 euros, then motorcycle, Sokol. This is very vintage though. A painting and a lot of land, all for market values that are being shown on the table. Of course, you're a counselor, and Yanis trusts you as a counsel, so they say, there's also a loan that I took and I need to give it back very soon. Or the loan interests are going to be 100,000 euros.
So imagine that he needs, for example, 70,000 within a week, and if he will not get it in the mediation session, that he will have to assume a loan, and the interest would be 100,000. So we're just going to ask you, let's imagine that the offers that we will give you are the final ones. So your brother says, take it or leave it, and it's actually take it or leave it offer. And just raise your hand if you think that we should get the offer, or no. Raise the hand if you think that we should raise the offer.
The first offer is, brother says, take the house. Done. Take it or leave it.
Are we taking it? Who says yes? The rest says no, correct?
Okay. Second offer?
No, don't take, I see some heads shaking. Don't take it. Okay.
The second offer says, you can have 100,000 of my savings, but I get everything here on the table, but for the painting. You can keep the painting. Take it or leave it. You can have a motorcycle. Painting, motorcycle, and 100,000. You leave me the land and the house. Would you take it?
So painting, motorcycle, and how much savings? 100.
100.
Take it or leave it. Are we taking it? No? Leave it. Who says take it? Thank you.
Okay.
And the last offer?
I get the house, you get 70,000 of my savings, and everything else from the estate.
Are we taking it? We're taking it. I see we're taking it. Who says we're not taking it? We're not taking it. Okay, let's break it down. So basically, why we're doing it? Because to respond to the question whether we should take a final offer or not, we should ask ourselves a very, very simple question. Is it within ZOPA or is it not? If it's within ZOPA, it means that it's better than our best alternative. So it makes sense to say yes when saying yes is better than saying no. Correct? So let's check. This is Butner, right? So what's going to happen if we called him David? I'm sorry.
Sorry.
So what will happen if we're not gonna accept the deal? We'll go to court. The court will divide the estate half-half. We'll have half of the value of the estate, and then we will have to subtract 100,000 from it as an interest that we're paying to cover our loan. Is it correct?
No surprise. In Poland, inheritance procedure takes about 2 years, the least. So much longer than 7 days needed.
So what would be our reservation value? Our reservation value, if we actually calculate it, there would be half of the estate, that is 245, and then minus 100,000. It means that our RV was 145,000, which basically means that we should have taken all the free offers. Because it's better than what's going to happen if we're not going to take the offer. So,
is it intuitive? Not at all. Is it something that we can use? Oh, yeah. So ZOPAs are also dependent on various factors. And we'll try to take you with us through the mediation session with the lenses of ZOPA in our hand. So let's assume that we have different actors. Can I be a mediator? Let's say I'm a mediator.
Yeah, I'm going to be a counselor.
And
Why
we
not?
also have a company X. First question is, what are we doing here? What's our role?
I mean, it should be a very easy question to answer, right? I mean, we are on the International Conference on Mediation, so probably we should know what is the role of a mediator. Do we?
We ask our students these questions and they say, but that's okay. There are plenty of answers, and a lot of them depend on the style. But if we take a perspective of ZOPA, what can a mediator do with ZOPA in a mediation? First thing would be also to determine if ZOPA is there at all existent. And second, to make sure that parties are aware of it and of decisions that they make.
So from the perspective of ZOPA, and from the perspective of a mediator who is a problem solver, and we definitely agree that as lawyers, we are trained to be problem solvers. For example, a dear friend of ours, Mary Lou Frank, who is a professor in US, she is a psychologist that we think very highly of. So she always says an anecdote that her husband is also a lawyer and also a mediator. So when they were, it was ages ago, but when they were dating and they were starting their careers as mediators, the husband comes to Mary Lou and says, "Oh, did you help the parties find a solution?" And Mary Lou responded to it, "Was I supposed to?"
It's easy to guess right now that both of them, they present the transformative attitude to mediator's role. and what mediator is supposed to help parties with. That's why the whole concept of ZOPA and how mediators use it is less useful for transformative mediators than for facilitative and mostly for evaluative mediators. So this is also a note to be taken while choosing a mediator, which was already discussed today during the conference.
Definitely. So basically we're going to go through, let's say, mediation process, but approaching it from the perspective of a mediator. What Agnieszka as a mediator will be doing in each part of the process, and what I as a counselor who has an obligation towards my client, I'm not sure if I'm going to be talking about what I'm supposed to do, but I'm going to definitely talk about what is happening from my experience during the negotiation/mediation sessions.
We talked about the role of mediator. When we take the lenses of ZOPA, what's the role of a lawyer representing a party in mediation?
Just get the best deal. I mean, when client comes to me, and this is commercial case, client will not be happy with me saying that I had a nice process. The client will simply say, what did you get out of it? So that's why I think that my role when I'm going into mediation, I'm actually hoping for the result, because this will be something that my client will take me responsible for.
ZOPA plays a role even before we enter the mediation room as such. So what mediator do with ZOPA before mediation? We go through files, we go through pre-mediation briefs if sent to us by parties, everything to have a fuller picture of what the whole situation is about, and to try to grasp the idea of, is there a ZOPA at all?
Yep, so from the perspective of a lawyer, I would like to break it down to 3 steps. So first step is what I do is when the client approaches us, probably we're going to assess what's going to happen should the case went to court. I don't know if you do it, but I usually do it. So basically the first round would be giving simply the legal advice of what is alternative as to the court. Then there is another round of questioning. Usually there is not a meeting, so there's another round of questioning, and we actually learned about true interest of, and we had already specified what is the difference between position, demands, and interest, so we're not going to talk about it, but we actually learning what the client wants and what the client needs from the session. Then we come up to the strategy as to how to fulfill those interests to the biggest extent possible. We predict what is the situation of the other party, and that is something that I would like to raise. So when we discuss all of the information, so we discuss what would happen, for example, in the David case, we discuss what would happen in court, then we're learning about the long shard, then we're learning about the interest that will be subtracted. We're actually getting a reservation value. So this is the value that we would say, you know what, if we get better deal than 145, in my personal opinion, you should take it. So sometimes the reservation value in some way will be also clarifying the scope of our power of attorney with regards to actually accepting deals. Because we had, as lawyers, legal obligation in our moral ethic to act in a good faith and to protect our client interest. This is our moral and ethical obligation. So from that perspective, from the perspective of the ZOPA, only taking those offers who are better than our RV is actually doing our job.
But RV is only one end of ZOPA. What happens at the time is also very often bringing client down to earth as to the dream hopes, dream ideas, that you will get 1,000% of what you actually could ever get, or be overly optimistic. That's when the subjective ZOPA of your party is created.
So basically, I don't know if you have those clients who come to you and say, I want $1 million of damages. Why? What happened? I slipped. I mean, on the ice. And he will quote the cases. The problem is that the cases were in US and not in Europe, for example. This is a small difference, but it makes a difference. Correct? So we have to be realistic about what is going on.
So when we enter the room, and I guess that all of us have seen how mediation looks like. What happens first is, of course, the opening remarks of mediators. Opening session, opening statement, whatever called. This is the first speech that is being given at a table. And the whole process, how it looks like, the rules, confidentiality, and the invitation to collaborative approach elicits information sharing by all parties. Irrelevant is the number of them present at the table.
So basically the entire mediator's opening statement, however we like to frame it, is virtually screaming, make an atmosphere when you will actually discover if there is a ZOPA during the process. That you will actually share enough information to discover whether there is a room for an agreement.
That's why opening statements are a very peaceful tone, with the attempt to build rapport. This all helps if created at least towards mediator. It helps them with dealing with ZOPA at further stages, and we'll get back to it.
From the counselor's perspective, and I'm really afraid to even say it, but what we do is usually, I would break it down to, again, 3 points. Firstly, we want to anchor the conversation. Of course, when we're talking about anchoring, we're usually talking about first offer and anchoring us to the numbers. But what we do as lawyers, we also, for example, anchor us of what is the reality of the case in regards of legal framework. So basically what you're saying in your opening statement is how strong is your case, that you're willing to mediate today, however should the case went to court, etc., etc. So what you're doing, you're creating a subjective, you try to anchor a subjective ZOPA, so the other party, if the other lawyer is not prepared, not present, etc., will think that you have actually a better negotiation position.
Better leverage.
Secondly, sometimes you want to, and I hate it, sometimes you're in the position that you have to defend your position. So the first lawyer came, said the opening statement, the plaintiff, how strong is their case? So what you're doing, you're trying to balance it. How we call it is de-anchor the session. So basically what you're saying is that it's not that simple. If it was that simple, we wouldn't be sitting here, we would be in court. From our perspective, what is happening is, so we try to balance it. And I'm really afraid to say the third one. But sometimes mediators want to anchor, sometimes lawyers want to anchor mediator as well.
There is the principle of neutrality of a mediator. What Andrew Goodman says is to put a stress of the understanding of neutrality, not as something that you will not stand on any sides, but as something that you will represent both sides to the same extent.
So basically, the point is whether mediator's opinion or how mediator behave affects the outcome of the mediation session. And officially, we would say, no, of course not. Unofficially, we're saying yes, otherwise the party wouldn't need us. Firstly, we have an effect as mediators on whether there is a settlement or not, but also on the particular terms of it.
When we move to information gathering, one of the most powerful tools in mediator's hand is a caucus. A caucus where you do venting. And venting has two aspects. First, get the idea of every factor that plays a role in a multidimensional ZOPA of one party. And then to decide how important these factors are and what role they play. To be very brief, because we're running out of time.
Exactly. So as a lawyer, there are two strategies that you can follow. My strategy is always to provide mediator with our statement as to our interests, because Agnieszka will not be able to help me if I will not share with her what I'm looking for today. Not details, but just hints as to what is important for me. But where it comes to the details and where it comes to my RV, my understanding of ZOPA, it's sometimes even damaging for the process if the counselor come clean to a mediator during the first session. And I'm saying that with full responsibility, because I, as a mediator, would never believe when during first caucus, first 10 minutes of a session, lawyer would say to me, this is our final offer, this is as low as we can go, and we virtually cannot give a penny more. Would you believe it? Of course not.
Deem it a bluff.
So if it wasn't a bluff, it would be very difficult, because we would be challenging him, we would be brainstorming, we would try to pushing him a bit further, but he wouldn't be able to go there.
After caucuses, mediator is the only person in the room who has a full or the fullest scope of information on the case and whether it's even possible to settle. So, if after a couple of rounds of caucuses, for example, you as a mediator see that there is no ZOPA, there are a couple of questions you need to ask yourself, and we know no answers to them. How long shall we put pressure on parties to move forward? When it's a time to call a meeting to an end? How long there is a bluff? How long there is the lack of a regional case assessment on the end of parties, or it's just stubbornness? We need to answer these questions in each particular session.
Correct. From lawyer perspective, the farther it gets, it's very easy. I want to actually find the solution, learn as much as possible about how the ZOPA looks like, and push it as far from my RV as it's possible. Correct?
In one word, to get the best deal possible. So what mediators care about? Do we care about the discussion to happen within the ZOPA, for options to be raised within ZOPA? Probably this is what we do in sessions. And we turn back parties saying, no, ducklings, come back. You're moving backwards.
Yeah, so this is basically how the session through the lenses of ZOPA look like. Obviously, there is also an element of settlement drafting when we verify, as what we did, verify options, whether they are actually beneficial for us through the lenses of ZOPA.
In terms of settlement drafting, our idea is that mediators' responsibility is to make sure that there are clear understanding of the terms of settlement, and parties have the idea of the option placement in or outside of ZOPA.
However, this is not mediator's job. If the parties negotiate within the ZOPA, and we know that they negotiate within the ZOPA, mediator's job is to just make sure that the conversation is civilized, and that's it. If they're doing fine, let it be. No need on our side. We are not needed.
The ethical obligations of lawyers?
The ethical obligations of lawyers. I would say that from the perspective of ZOPA, the ethical obligations of lawyers are to make clients settle if there is a ZOPA. Then if the other party offers something that I have even assumption that is outside of his ZOPA, so basically what I'm saying is that the other side is not taking a good deal, is agreeing on something they shouldn't, we have to make sure as lawyers that the offer, that the agreement is rock solid, so it actually can be enforced. Then also trying, if we're moving within the ZOPA, try to push it as beneficial for your client. That's simple as that. With mediators, we have more problems than obligations.
At the settlement drafting, what's important on the side of mediator, or the perspectives that we believe may be kind of difficult for us, is the need of a fair resolution. That is very deeply rooted in hearts of mediators. And our standing on this is that so long as the agreement is in ZOPA, that's fine. No need of a fair agreement by 50-50. It's unintuitive, but let's follow it. And the bias for ZOPA. Very often, especially as mediator lawyers, we have a very, very concrete idea on how the ZOPA is supposed to look like. And we will push parties to our concept a little bit too much.
And also, there is an ethical problem. Should we, as mediators, try to push to force an agreement on the party if we actually know that they have a better alternative than what is on the table right now?
There's a very quick case of a model girl. Her ex-boyfriend put an acid on her face. She was insured, so the mediation happened with the insurance company. And then the girl came with a lawyer, counsel, And she said, oh, I need to undergo all the surgeries. I'll need 30,000
In caucus.
in caucus. Then comes the caucus with insurance company, and they say, oh, we can pay up to million, 100,000 would be nice. Is the agreement of 30,000 within ZOPA? It is. The girl said it's okay.
Not up to us.
What would a lawyer do of the other side? Would they say, okay, we'll give you 30 because it's way below what we expected it to be? You probably wouldn't, because then the other side would not be happy. We're all taught not to accept the first offer. So we would go even lower.
So basically, just to summarize in 5 sentences, when we're talking about benefit and gains that mediation provides us with, is that when we actually reading about negotiation, there is a constant battle between struggle for both parties to reach a settlement if there is a ZOPA, correct? So both parties want to have a good deal. But the problem is that this is in both parties' interest, but this is in no one's interest to actually reveal what is their ZOPAs, because there's going to be exploited. So from the perspective of ZOPA, mediation is a wonderful tool that actually provides us with the opportunity to have a third neutral party who will understand what is ZOPA and guide the discussion so that the parties can come to an agreement within it, and we will be moving forward without the risk to being exploited for sharing too much information.
So when we're speaking at a conference on the benefits of mediation, this may sound cliche, but one of the biggest benefits of mediation is mediator as such. And this is our job, to use these mechanisms to the fullest extent.
So last sentence is that on the stock exchange market, the discrepancy as to the information is something bad. In mediation, we can turn it actually to our advantage. Thank you so much.